Welcome everyone to another one of our Sustained by Grace Ministry and Outreach program, where we seek to nurture you back to wholeness and life. It's another exciting evening as we look at the topic estate planning. Yes, and everyone needs to know how to plan for or plan with someone about their estate. It's a very important topic that affects many Jamaicans. And tonight we are here to explore this topic. There are so many things that we can look on when we are looking at estate planning. But tonight and next week, we are going to be exploring 4 main areas: tenancy, inheritance, willing, and titling. So if you have any reason at all where estate planning is concerned, you need some knowledge, you need some advice, this is the program for you. Tonight, again, I want to make special welcome to our guest presenter, to all those that log in and join with us tonight on our Zoom, and those who will be logging in later, as well as our viewers on YouTube, and those who will be viewing the program even later during the week. We are going to be looking at a scripture that speaks to the topic that we are looking at tonight. And a lot of persons don't know that everything is in the Bible. The Bible does not leave out anything at all, right? So let's look at the scripture. The Bible said, "Ask of me," Psalms 2 verse 8, King James Version, "Ask of me and I shall give thee the heathen for thine inheritance, and the uttermost part of the earth for thy possession." Songs of Solomon 8 verse 11, King James Version, "Solomon owned a vineyard in Baal Hamon. He leased the vineyard to tenants. Each was to bring for his food 1,000 pieces of silver." Yes, so the Bible does speak to estate planning. Right, so we're going to go into our program as usual. We don't tarry, we go straight to our program. But before I do that, there are some things I want to share with you tonight. Just give me a moment. Right, so we have Mr. Brian Walker with us just a few days ago, and he has some scrub that he's promoting. And he has a special for Teachers Days for all the teachers, mothers, all who want to participate. It doesn't matter. You can call him and contact him. So just look at this brief ad for me. Thank you. So that's Mr. Walker. If you have any need to get any of those stress scrub, a lot of persons are going through stress. You have probs, you have lotion, you have cream, you have a lot of products out there for stress, and he's promoting those. So if you need those products, you can contact him. Also wanted to relax for a few minutes as I share with you also another ad, our Sustained by Grace Ministries. We have been working on this video for so long, and it's now available. So just take a minute and just look at what we offer as we go along.
Welcome to Sustained by Grace Ministry and Outreach, a unique ministry that seeks to heal the body of Christ through our various program offerings. These innovative programs are geared toward the nurturing of the whole man, spirit, soul, and body. Among the available programs are the Adult and Elderly Support, Relax, Entertainment, and Laugh Program, REL. REL. This program is designed for persons heading for retirement but are unprepared, empty nesters, and those struggling with depression, mental health issues, and loneliness but need expert advice and help. Our Youth Ministry Club is here to help young people who are losing hope because the devil is trying to stop their progress. Learn social and life skills that will prepare you to be the future leaders and winners. Sign up now for our club. We also have an exciting entrepreneurship ministry club. This is for those who need additional income, want to adequately provide for your family, get free from your 9-to-5 job, and to use your business as a ministry to serve the kingdom of God. Get involved today on your way to financial independence. Are our pastors and leaders suffering from burnout, stress, depression, loneliness, and a feeling of giving it all up and throwing in the towel? Well, we have our pastors and leaders support program. Call us today and let us put you on to an expert support team member. We also offer Christian counseling to anyone who needs it. Become a hand extended as a monthly subscriber to our education and health fund. Proverbs 19:17 says, "He that hath pity upon the poor lendeth unto the Lord, and that which he hath given will he pay him again." Donate today. Register now and don't miss these amazing opportunities. All our programs are done online and our prices are very affordable. Please see program listing and costs below and how to get in touch with us. God bless you. Sustained by Grace Ministries and Outreach, nurturing you back to wholeness and life.
Thank you very much for listening in. And that's all about our program. We have been announcing it over the weeks, but we finally get this video out. That is much more easy for you to view and have some knowledge of the different products that we offer. So again, as I said, welcome everyone, and we're going to go right into our program. We have with us our guest presenter tonight, and I'm going to take the time out at this time to introduce him to us. Just a moment. So we have with us Sir Kirkpatrick Russell. Our presenter was born in Manchester, grew up in Clarendon, and lives in Kingston. He got saved in grade 3, and he is a member of the Good News Release Center of the Prophetic Church of God. He has been very active in the ministry, and he served as one of the 2 international youth leaders and as host pastor for the branch in Crooks Gate, Clarendon. He is an attorney at law, having been called to the bar in 2012. He recently transitioned from the government service to being a sole practitioner dealing with civil matters. He is also a justice of the peace. He likes to sing and wants to live to show the love of Jesus Christ to everyone. Let's put our virtual hands together as we welcome Mr. Russell to our platform.
Thank you very
Mr.
much.
Russell.
Thank you very much, ma'am, for having me. Greetings to Reverend Lemard and to yourself as a moderator today, and everyone that is online with us this evening. Thank you very much for the invitation, and I'll try to do my very best to facilitate the discussion this evening.
We're not seeing your camera, sir.
No, I'm asking to not turn on my camera because I'll explain afterwards. But yes, if you may. Yes, so today we are going to be talking. I hope everyone can hear me clearly.
Yes, sir, go ahead.
Thank you. We are going to be talking about estate planning, and based on the scope that was given earlier by Minister Lemar, I am going to be looking at 2 of the items today, and we will pick up next week with the other 2. We are talking about estate planning. And every one of us would have heard this phrase before. If we fail to plan, then we could very well just plan to fail. Yes. So as I was saying earlier, if we fail to plan, then we can very much plan to fail. And I don't think that that needs much explanation, save that it is very applicable to the topic that we are discussing this evening. I usually like to start with a story. So here goes. John Abel lived in a house that he owns in St. Mary. He gets married to a beautiful lady named Sarah, who became Sarah Abel. They have one son together that's called Finn Abel. However, John had 2 children before from a previous relationship, Sam and Ro. All of John's properties, his land, and also his bank accounts, everything, they are in his sole name, his name alone. He and his wife have discussed estate planning, but as many of us can, relate, they were always busy, so they never got to sort it out. Unfortunately, while at work on the construction site where he's employed, John fell and he died. A story like this is a very good one from which to pitch the topic of estate planning. And I'm just going to give a very simplistic view of what estate planning is. It simply is where an individual or a family, they come together to make arrangements in anticipation of death. Now, persons can do different things as they prepare for for this dark area, one that many of us are dreading from the moment we were born. And I'm going to start off by looking at something that I was asked a question about some time ago, and that is still a part of estate planning, but it is called a trust. Now, a person can decide that they're going to put their affairs in order and they're going to do what needs to be done right away, or they can leave it for it to be done after they pass away. The trust is one way that a person can deal with certain parts of their business while they are alive. And let me explain what this mechanism does. A trust is where you have a legal relationship formed, where somebody who holds a right or who owns something, and this person can be, or this person is usually called either a settlor or a testator. And that's based on how they choose to act. I'll get to that in a few. And what the settlor or testator does is that they give the right or the thing they own to another person called a trustee. And that trustee is not the ultimate owner. That trustee is to hold it for the ultimate owner, who is called a beneficiary. Now, whatever property they choose to be giving away is called the corpus or the trust property. Now, I mentioned this first because a trust can be done while a person is alive. And if it is done when a person is alive, then the inheritance that is to be given to the beneficiary passes from the owner to the temporary owner called the trustee, who is supposed to, at some later date, hand it over to the beneficiary. And if the person who is giving the right is still alive, then it is considered or called an inter vivos trust. Many times, though, what happens is that the trust mechanism is used when the person would have passed away already. And that that mechanism is usually called a testamentary trust. So it is done after the lifetime of the person who is giving the property or giving the right to the other person. Now, I want to know, go back to explaining what is an estate for those who are not aware. So having moved from the trust, which can take you either before the person dies or after the person dies, let us discuss what's an estate. An estate is everything a person owns. It stretches from shares, bank accounts, land, the bed in your house, the dresser, the movable items, everything. Broadly put into two groups: land properties that are, land related are called realty, and other properties that are not land are referred to as personalty. Now, I want to let you know that there are broadly two types of estates. There is a type of estate where before the person died, they would have left a will, and that is called a testate estate. And if they, like many persons, decided that, boy, it was too grim, or we couldn't settle down to waste a little time we had left with our loved one, and so the person passed away without a will, it's called an intestate estate. Now, let us look back on our story. In the story where John fell at work and died eventually, it would depend on the planning that he would have made or failed to make, that the necessary steps would have to be taken. So if he left a will, then what his family would have to do is to have that will probated, taken to the courts to be considered, if it is a valid instrument or it's not valid, it was not he who did it, or he did not do it willingly. There are several reasons. If he did not make a will, then what would happen is that his family would now have to rely on what the law says for distribution of assets. And so they would have to get what is called a grant of letters of administration. Now, we're talking this week about wills and inheritance. It is important for us in a discussion like this to ensure that we don't look on the realities of life as something that we should dread. We need to ensure that we make the necessary plans. And if we fail to make the plans, then no one is going to help us, because when the time comes, we can just expect that there are certain things that are going to fall and are not going to be as how we would want them. For the persons who take great care in planning, they would err on the side of what is called the testate type of estate. And this estate, I always like to mention when talking about the testate estate, Hebrews 9:16 and 17. It says, for where a testament is, there must also be necessity, also of necessity be the death of the testator. For the testament is of force after men are dead. Otherwise, it is of no strength at all while the testator liveth. Now we can look at this as against the trust, the inter vivos trust I spoke about earlier. The inter vivos trust is something that is alive when the testator or the settler is alive, because it comes into motion. It's only that the ultimate owner doesn't get it until a certain thing or a certain event has taken place, usually reaching a certain age or reaching an age that the person who is giving it wanted them to reach. But this scripture here is actually telling us that for those who have planned to use the testate estate, then that comes into motion when the person who is making the different plans has passed away, when that person is already dead. And so we usually say that where the testate estate is concerned, it's ambulatory. It takes effect on death. Now, many of us know, or would have heard about a will before. When you're passing an inheritance, it's a very good way to be certain and to let everyone else know that, hey, this is what I wanted, or what I want when I pass away. So simply put, it's a written document that sets out what you have to give and who you want to give it to. Now, there are circumstances when a will doesn't have to be written, and those circumstances are, usually what they call privilege wills, where men who are at war and would not have the opportunity, or they are granted under the law the opportunity to circumvent or go around the writing element, they are allowed to speak out. And once the necessary persons are there to confirm what was said, then that will be able to stand. I already told you that it is testamentary, ambulatory, and I want to also tell you that this document, or that is called the will, is something that can be revoked, or you can change it. It's not something that is cast in stone. So many persons change their wills as they go along. You have persons who are kind to you as you get older, and you want to show them some respect and some kindness. You can amend the will. So you can say, oh, I'm going to make a later will because it is the latest will that is going to become the one that is going to take effect. Now, based on the law, if you want to know about how, or what they call the formalities of a will, or what should be there if you're going to have a will, you look at Section 6 of the Wills Act, and that simply tells us it must be written. It's supposed to be signed at the end of the will by the person who is making the will, or by somebody else who that person elects. And it is supposed to be signed by the person who is making the will, called the testator, in the presence of 2 or more witnesses. And all of them have to be present at the same time. They are supposed to, they don't need to know the contents of the will. They are just to be, all persons are to be there. Person who is making signs, and then the other 2 sign, and the will is put away for safekeeping. This is what I was saying. Now, if a person is unable to read, then that person can make their mark, and that would suffice in terms of the signature, which is required under Section 6 of the Wills Act. Now, I always want to remind persons that because of the nature of a will, and when it comes into focus. We have to be careful not to have persons just making corrections all over the place and leaving it like that. So the law requires that any correction that is made on the will, if you want it to be to stand up to scrutiny, it must be treated just like how the will signature was done. So if you cross out something, the testator must make his or her mark or signature, and the witnesses should do it the same thing to show that everybody was there and it's not something that is tending towards hanky-panky. Now, the other thing is that many persons believe that when you are making a will, yes, a JP is necessary in our day-to-day living, but you do not need to have a JP witnessing the will after the testator or the person who is making the will has signed. You don't need that. In fact, if you do that and you have a JP, it can be looked at as what is called superfluous attestation. And you'd have to say that it's ignorance that caused you when you're putting your papers towards the court for it to be considered. All right, now there's another way. If you make a will and you decide that, oh, I want to change certain things that I would have said, then you can use what is called a codicil, which is something that is used to make changes or amendments, or sometimes to revoke certain parts of the will. Oh, section A is totally to be put aside, and I want this to be instituted instead of section A. And as I said before, because of the nature and the person not being there, everything that is being done has to follow the formalities, has to be signed by the testator or testatrix if it's a female, and it also has to have those who are witnessing do the same kind of signature. Many persons are afraid to make wills because of the myths that it's a thing that will hasten your death, too complicated and expensive. It's not for young people. And if you make a will, then boy, your life is done. Instead, when you make a will, whenever you plan in this sort of a way, you are ensuring that you are making provision for the security of your family. Let us look back on the story of John. John would have had his family, and and he would have had his wife and child, and he could have very well made preparation for the other two children outside. But guess what? The wife and child now will have to open the legacies that are left to them to be shared in ways that perhaps not even John would want it to be, because John wouldn't want everybody to come now into a situation, I'm just saying, where there will be fights and quarrels. He would want, I would believe, a situation where there would be a peace and calm, so he could get somewhere else or put together some funds so that the other two have their schooling money put down, so that the other two can have a proper place to lay their head, those sort of things. But now, under the situation that he has died and left, there is no proper security for his loved ones. There is the possibility, the high possibility, that there will be family disputes. Because what if those two were never a part of the the child he had with his wife? And as I was saying, if you fail to plan, there can be just that automatic, although it's paradoxical sounding, but it's true. Once you fail to plan, then guess what? You don't have a chance anymore to determine how things are done. And you are going to fall into the lap of a system or a scheme called intestacy. Now, you might ask me, who is the person who can, think about this estate planning? Anyone once you have reached your majority, which is 18 years, and also you're of sound mind and able to reason, so you're not influenced by anybody who would say, oh, do this or do that, because that is a ground on which your will can be invalidated. And as I just give you an example here, what you can give away once it has value, and value is something that depends on and will change from person to person. So if it's your Lada motor car, if it's a painting or it's a property, you can give it. Just for you to be clear, person who is making the will, if it's a male, it's called a testator or a testatrix, and then that person will leave in charge a person who is called an executor, if it's a male, or an executrix, if it's a female. And whatever is given in the will, the properties, the rights, the interests, those are called the bequests and devises. And then now the persons who sign at the foot of the will and watch and make sure, and they will have to take a part in the probate process, are called the witnesses. Sometimes they call them the attesting witnesses. Just to be clear, and I'm coming down. Oh, somebody's asking something.
All right, Pastor, I was just saying, if a person, all right, use the example with a man and a woman, a child and outside kids, but if there's no outside children, won't the property automatically goes to the wife and the kids? Would that take in siblings or other relative, or just the wife and the kids?
Right.
Who are at home?
Yes, and that's a good question. So yes, if it is that there are no outside children, then it would be, the intestacy would provide for the immediate family first. The only way siblings come into the play is if there are no immediate persons there to benefit, like wife and children. Once those are there, a portion is given to the wife, and then the remaining portion is shared among the children or given to the sole child. But the problem comes in, Minister, where you have a situation where there are probably outside persons who have competing interests. And that is where those are the persons who have to make sure that they make the necessary plans. And there are sometimes some persons who, some children that come into play while the person is ill or dying. So those children were conceived when they were healthy, and they are born, when the person dies. Those children as well will come in to stand to benefit if they are a part of the equation. But yes, as you were saying, indeed. Now, just to let you know, the persons who you are leaving behind to do your business, remember the trust we spoke about. In the trust, we have a trustee. Now, in the testate scheme of things, you have the name of the trustee is the executor or executrix, and this is the overseer, the person who is in charge. And you can have up to 4 of them. And there are sometimes persons who don't put the names of the persons out, because, as I said, a will can just be, you can write a will on your own. The only thing that I would say is that you have to follow the formality of the signature. And once that is done, then there are certain things that can be gleaned from the will. So if you say, oh, Minister Lemard, I want you to take charge of the children if anything happens to me. I want you to put them in a good school. I want you to, wind up all my accounts and keep the monies and give to them, etc. Then if nobody is named as the executor or executrix, Minister Lemar would be the person who would be called the executor according to the tenor or according to the context. And so that person now would be given the opportunity to take charge of administering the affairs. Now, there's a funny thing. If you are not named as an executor, you could very well be considered executor according to tenor, but then the name carries a lot of weight. Once you are named as an executor, you are given what is called a grant of probate. If there is no executor named, then quite likely you are going to be given what is called letters of administration. But the will be annexed to that LA, we call it LA. And so even though you're executor according to the tenor, you were not so named in the will, and so you're going to get a different type of grant at the end of the process. So it is good for us when we are making our wills to appoint a person or persons who are going to be in charge of our affairs. Now, the will not be valid, so it will no longer be a testate estate if the will is not signed. Another one is if once you get married, your will, becomes null and void, and you have to do it over because certain preparations and also consideration must be given to the new institution that you have stepped into. The will is not going to be valid if it's destroyed. That means destroyed by fire, destroyed by burning, thrown away, torn up, rat eat up the will, then the will no longer being. Also, as I said before, you may have a codicil who, and through that codicil, you would have said certain parts or all of your will that was made before is to be discontinued or not considered. So that would cause the will to be out of the place. And also there can be declarations to the effect that it's no longer valid. These are just some things that the executor can do. They are the administrators, they are the trustees. They're to make sure that whatever your wishes were are brought to the fore. So they are to retain the lawyer, they are to make sure that the documents are done, they are signed up and they are stamped, lodged at court, and they are to make sure they check until the grant is made. Once you get the grant, then they will make sure that the assets, whatever the person who died owns, they are called in, they will take, especially if it is property, they will become the interim owners or the owners for the time being, and then they will give the transfers. Now, some transfers are not immediate because you have some cases where you have children involved. And once children are involved, they don't have the capacity to deal with certain property and all that kind of thing. So those will have to be held at the direction of the executor or executrix until the child becomes an adult, then they can transfer to them. Now, you have some unfortunate situations where the executors don't get a chance to finish what they start. And this is another instance where the person who is one of the beneficiaries, who is an adult, can apply to the court to step into the shoes of the executor. Now, yes, that's one of the things that can be done, and they can get what is called letters of administration with the will annexed. But if that executor did their own measure of planning and had had a will made for themselves and appointed an executor in their estate, then that executor now could do what is called a chain. So while they are clearing up the affairs of the executor, They can also clear up affairs that the executor should have cleared up while they were alive, but did not get a chance to. Yeah. Is it clear so far on the testate part of things?
Yes, it is.
Well, okay, I'll just go quickly into this one and then I'll hand back for any questions. Now, for persons who do not, I should say because of fear, many times persons are not ready to make a will. It's just yesterday that I was speaking to one of my relatives and we were, talking about some relatives of theirs that died recently. And when during the last moments, the relative was, advised to just make, say what you want to be done and, reduce it to writing so that, everybody can be clear. Relative did say what they wanted to be done. When it came to the signing, every time they would try to get the person to sign the document, the person got ill. So, it seems as if the pressure went up, the sugar went up, because facing those final moments is not easy. So for many persons, they end up falling into what is called the category of intestacy or the intestate estates. And so if our John, in my example, didn't leave a will, then what is going to happen is that his wife and all his children will have to look to the Intestate Estates and the Property Charges Act when they are going to look about his affairs or administer his estate. They will also have to look at the Administrator General's Act if there are any children who are under 18, persons who are under 18 rather, who are children. Now, the Intestate Act says that the person who is going to be in charge is not an executor or an executrix, but is what is called an administrator or administratrix, or another word for it is a personal representative. Now, this personal representative can be one of two people. It can either be the Administrator General for Jamaica, who takes on cases where all the cases where you have a person who died and that person never left any arrangements, but they left children, they left minors as beneficiaries. The Administrator General is the one who steps in to ensure that the interests of the minors are protected. If there are no children or no minors, then one of the adult beneficiaries will take charge of the estate. Many times, that adult beneficiary will actually be the wife or the husband that survived. Now, I want to tell you that once a wife or husband is in place, they are what you call the proper person to apply for a grant of letters of administration. We would recall that if you have a will, the grant or the thing that the court will issue is called a grant of probate, and only an executor or executrix can apply for that. Under intestacy, what you apply to the court for is a grant of letters of administration, and the proper person to apply for this is the surviving spouse. If the surviving spouse cannot handle, what it takes to look at the estate and sign up documents, they can give the duty to someone else. And when they do that, they would have to give up their right. So they would have to put away and say, oh, I'm not interested. So that they'd have to send something into the court to renounce what the law gives them as a right to apply. Now, if you have no surviving spouse, and you have 4 brothers, and one of them wants to apply, that one can apply, or 2, or however many, but whoever is applying has to make sure that they give notice to the other persons who are also able to apply. Now, in doing this, remember, under the will and the testate scheme, you would have just one person who is chosen, and this person becomes the elect one who is supposed to take charge. But under the intestate estates, there is what you call a table of distribution. As I said before, it starts with the spouse, and I will tell you that spouse here has a very unique meaning, because it can mean husband and wife, but it can also mean in a situation where 2 single persons are living together for beyond 5 years, then they have been living as man and wife. They can be declared as spouse, and so that person would have the same sort of right. Below them would be the children. And I also want to say that we no longer have any bastards. The Status of Children's Act makes it clear that once you're a child, you're a child. So whether you're in, of the half blood or the whole blood, or the 3/4 or the quarter blood, you are still a child and still have an opportunity to participate in the distribution when the time comes. If there are nobody at 1 and 2, the next person to apply will be the parents of the deceased. If there are no parents, it goes down to the siblings. And then if none of those, then the grandparents, and it terminates at the uncles and aunts. Cousins are not able. So if you have an estate where only cousins are involved, then quite likely the property that would have been left would spring back to the crown under what you call bona vacantia. And that would just be that. Now, if John, in our case, I use the letter A. If A dies, leaves his wife and children, wife is above the children, so she has to give consent if one of them is to be applying. Give the consent, or if she doesn't want to do it, that's the way she will renounce her position. If they're on the same level, as I said, with the brothers and sisters, then they give notice to the others. So 2 are applying, they send a notice to the 3rd and the 4th, and the notice has to be attached to the application that is being sent to the court. Yeah, so that's it. I don't know if you have any questions. We can go ahead with that right now.
Okay, just thinking about, I know you said a lot. No, my viewers are listening. What I would like to know, and I'm just trying, you say that now, if per adventure, something should happen to one partner, yes, and the partner has kids, those kids automatically becomes inheritance to what both partners own.
Okay, so you're talking the outside children now?
No.
Oh,
just regular normal family.
Okay, normal family, yes. So if so A and B are married and A dies, and A had a house and it is in his name alone, then what happens now is that house, no, first of all, the A, once A dies, his estate comes alive. So his estate comes alive, and that means that somebody will have to apply to administer his estate. If he left a will, it will be the executor or executrix. If he didn't, then it's going to be, so if he left a will, he could say, oh, these children are misbehaving and they are giving a lot of trouble. I don't want them to participate in anything I have. I'm giving my property to X. I'm giving it to the church. So, and then in that case, they get nothing. But if it is a situation where he leaves it and he doesn't allow, that sort of preparation or that estate planning side of him to come alive, what will happen is that the law now is going to say that that surviving spouse is to get a half, and then the remaining half now would share for the more than one children. I think there's a way that it is styled in the law. I'll start with that next week, but the law sets out clearly how it's to be shared. If it's one child, the wife gets a certain portion, and then that child gets a certain portion. If it's more than one, then the wife gets, I think, a half, and the remaining half now is cut up for the rest. Yes. So all of their names will go on the title now.
And you're saying it doesn't automatically go away. What if the children aren't interested and just want that surviving spouse to have
what they can do now is they would still administer, but then when it reaches to the point of the transfer, they would write something to let the registrar know that they don't wish for they wish for their portion to be transferred to the parent. But many times what happens is that when you're doing that, it's going to be treated like a transfer. You're transferring something, and that may have certain fees put towards it. So once you're willing to pay that, no problem.
Any question from anyone else?
Okay, so good night, Mr. Russell. Great presentation.
Thank you.
Just a follow-up on the same question that was you have just dealt with, our clarity. Rather, you're saying that if the person died, having children, of course, but did not consider them, gave it to an absolute stranger, the court has the power to deal with that, change that desire of the person. If it's challenged.
You put it in a will?
Yes.
Okay, well, it's a very good question, sir. Well, those children now could challenge that situation if they have information, stating otherwise, or if they feel that that situation came about because of some sort of fraud. So it is not it's not willy-nilly that the court just going to jump in and say, because the court is more inclined to support the person who made the will once the formalities are complied with. So once you go through the Section 6 and those things are passed, you would have to come with some good reason now to say, notwithstanding all of that, that was just a sham, and he actually wanted this to be the case. And once you can prove it, then the court can, undo that sort of situation and put in place what the person would have wanted actually.
Okay. And the matter of the will, I know in some way you mention it, but when it comes on to gift, I know you know about that. You gift your property as it will. Is it a different thing when you're willing something or if you're gifting it, and there's a procedure to get that the same in the court?
Oh, you're talking about like a deed of gift?
Right.
Okay, well, it's sort of different in the sense that you still have to have persons who confirm the gift. So you won't just have a person saying, oh, I give you this and I just sign it. Somebody has to be there who signs it, so that it has a sort of weight, and that now can be used to for the titling process. I'm thinking next week I'm going to talk more about that, deeds of gift, but it is kind of similar but different. The difference between that and the will is that whilst a deed of gift can be used while a person is alive, to give you the property because they see that, you and them have a good relationship and they want to make sure that you have some provision. But a will actually takes effect once a person dies. So it is there, and all along it is just what they call a paper writing. But when the person dies, it can be considered to be their final wishes and the court will stand up to it. But I promise you, sir, next week we'll talk about the deed of gift. I'm making sure I make a note of it.
Okay, thanks.
No problem.
Any other question? Okay, what if, Pastor Russell,
Yes, ma'am.
there is a case where, say, a parent leave property for the children in will, and you want to probate that property, but it took a very long while, and say the papers got lost in the court or somewhere there. Oh, well, how
Will
can
be
that?
lost in the court, hopefully. All right, let me tell you, I heard about one case today. I was speaking to somebody and they said that, let me tell you about that, and then I'll go to your question.
Okay.
You have some situations where parents leave a will and children are in the property, and then when they want to probate the will, one child decide that, guess what, me help mommy buy this, me not come out. That might be a problem that arises, and those things can cause the process to be very long and winding. And what would have to happen is that you need to get the court assistance to deal with that person. Sometimes those are battles that can end up in death.
Okay.
But then now, where you said now, if the will is lost, many times you have copies of the will. So there's a process that they have that they call and proving the copy. So if you have a good copy, like, that looks like the original, and you still have access to the attesting witnesses, or if they are not there anymore, you'd have to perhaps rely on the handwriting. They could look on documents that were signed by a lot of different things that can be done. And then you can prove the copy, and the court would treat the copy in lieu of the one that is lost. So I'm thankful for that question, ma'am. When you are making your will, it's good to have a little photocopy somewhere. It's good to put stuff good, but it can get lost. Thank you very much for that fact right there. Can get lost, and when it gets lost, the problem is that many times when it gets lost is when you would want to make sure you have it, because that's where disputes are going to come up, and if it is not there, persons are going to be involved who were not supposed to be involved. And if you don't have something to stand on like a will, then you just get salt or not.
Thank you.
Yes, ma'am.
All right. Any other question? You can put the question in the chat if you don't want to open the mic and ask. If not, I'll ask my final question and that's it. Okay, go ahead, Marvin.
Just before, I was going to put this in the chat, but since somebody wants to speak tonight. All right, so Rev,
Yes, sir.
Witnesses, is there a limit as to will, is there a limit as to how many times you can change that will?
No.
And also, okay, so you said no.
No,
all right.
there's no limit. I'm glad for what you said earlier. There is a little thing with the witnesses. The witnesses, one should try not to use witnesses who are getting something under the will. Because although there is no there's an act that has been changed. It evades me now. But there's, I don't remember if it's the Administrator General's Act, where you can make certain representation to the Administrator General to prove that really and truly you had no ulterior motive with the person naming you in the will and making you sign as a witness. But to avoid that, please let us just use persons who are not getting anything under the will, because you'll have to go around some you'll have to go around some formalities to get that person still benefiting if they have signed as a witness. It is not the same case for the executor executrix. They can actually benefit under the will without more. But if you are a witness, then there are other hurdles that you will have to surmount. So let's be careful about that. Thank you, Sir Marvin.
Okay, sir.
Blessings. Any other questions? Yes, it's back to Minister then.
Right, I totally forget the question. But a lot of persons are afraid to make their will because I hear you speak about the trustee in your opening remarks. And I don't know, but most time when you watch the movies, you see where children are killing their parents because they want it and they're taking too long to die.
True.
So I think a lot of persons may be afraid to entrust their property to their children, or even let them be aware that they left a will with their name in it because they don't want them to hasten their deaths. Is there any way that the person can protect themselves? Well, no, once they're dead.
Well,
what can be done there?
A will is someone's private business, and what I would do if I'm afraid that the children, are going to put me in a little position that I'm not going to be comfortable, is not tell them about it. But the problem with many parents is that sometimes based on how children think and how they, will have certain discussions. I know that this house belonged to me when my mother and father are gone. Then the parents don't have to try to kind of placate them. But really and truly, you can keep mom on it. You can have no discussion on it, and then you can do it as a private kind of situation where you decide who you're giving the thing to. And if you are afraid to keep the will at home, you can put it in a safety deposit box, one, or you can have it at the Island Records Office. That's another. I sometimes think that some persons don't put up the will carefully enough, and then persons get sight of it, and that's where the wars begin. When you're gone, then you can only dream them, excuse me for saying that, and tell them to behave themselves. But then when you are around and all of this thing crops up, then it's a whole different ball game, which can involve your early demise. So I don't know that there's a lot that can be done, save that you should treat with whatever information you have circulating about your will very confidentially, and keep it down until you're gone.
Okay, thank you very much, Pastor JP, Lawyer Russell. Sir, can you pronounce that first name again for us?
Tershata.
All right, so I will not twist my tongue by calling that name. But we know who we have on board tonight, and next week we are looking forward to getting even more exciting information, because we're going to be looking at tenancy.
Yes.
And titling, and tenancy is one of the great problems that we are having in Jamaica, with persons becoming tenants in our home, and we're having a lot of situation and problems, and we need some help. So we're looking forward to having him next week again, and we're asking you to tune in to get more information. And if you have no further question, I just want to say thank you, sir, for being with us tonight. Thanks everyone for logging on, for those who are viewing on YouTube, and those who will be joining us next week. It's always a pleasure to be with you.
God bless you, and I look forward to next week as well. God bless you, everyone.
Thank you. So before we go, I want to share again one of our ads with us. And we are seeking subscribers. We have our education and health fund. We have schooling coming up. We have some children we want to sponsor to go back to school, but we cannot do it alone. And the Bible said, if you give it to the poor, you lend it to the Lord, and God is no man's debtor. So you can start it as little as 500 to as much as you want. We want monthly subscribers. So if you want to subscribe and contribute 500 per month towards that fund, it won't be used for any personal use. It will go straight towards our educational and health fund, and persons can benefit from that fund. All right, so thanks for viewing, thanks for watching. See you guys same time, same place next week. Bye, everyone. Bye again, everyone. Just a bit of information for those who are still watching. In case you need to contact Pastor Ross or any estate planning situation, you can call him at 350-9024. That's 876-350-9024. 876-350-9024.